trouble in your eyes now, but I know there's always a way. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything much smoother again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken, make the whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as new. Hey, Daniel, I'll fix you up for you.
Well, welcome everybody to the show. Sorry about that. Today is Judge Phyillis Webster. So let's get started with this. So let's share screen. Sovereign citizen in court. Let's Judge Webster. Let me make this bigger. And
on standby on Mr. DeBus. Although I'm not attorney of record, I will be standing by though.
All right, and that's what I'm going to call now because it looks like it's between Mr. DeBus and Mr. Cochran. Well, I can't call, yeah. Mr. DeBus, you want to start your video? Okay, we are back on the record in 2023 TR 2777. State of Kansas versus Anthony Edward DeBus with Jared Regier for the state, Mr. DeBus in person, and with standby counsel Darren Patterson. Standby because my prior contacts with Mr. DeBus led me to believe that he, even though he wants to represent himself, there's much about the legal system that he doesn't know or understand and would need the benefit, or would certainly benefit, period, from Mr.
Quickest way to shrink your prostate.
Best way to fix prostate problems?
Patterson's representation. So, Mr. DeBus, at this time, you want to talk to Mr. Patterson and take advantage of his knowledge and experience in the legal system concerning this no driver's license charge, registration, and insurance violations?
Let me ask first, are we on the record? Is there a court reporter present?
Is there a court reporter present? This hearing is live. It is being recorded. Is someone sitting here with their little fingers clicking across the keyboard? No.
So you're saying that this is not currently a court of record?
This is a court of record because this is being recorded, subject to transcription at any time.
Okay, I would ask for a copy of that transcription.
Well, when you file a written motion and pay the transcription fee, sir, that will be arranged.
Okay, and Phyillis K. Webster, will you please recite your oath of office into the court of record then today?
No, sir, I will not.
Why are you refusing to do so?
Let's move along.
I would please like to have that question answered. On another note, I am appearing specially, not generally, under threat of duress and further coercion by the state of Kansas Corporation.
All right, sir. I did take my oath when I was appointed and when I was elected subsequently. Now, what is it I can help you with today? Do you want a trial, a jury trial, or do you want to enter a plea today?
It seemed like last time we had court, you entered the plea for me.
I did, because you would not.
Okay,
But yet what you were saying suggested you wanted a trial, so I entered the not guilty plea and set it for trial. Somewhere along the line, you led me to believe you wanted a jury trial as opposed to a bench trial. Had I been making the decision, I probably would have said bench trial. But somewhere along the line, you've made comments to make me think you wanted a jury trial. Now, I have not seen, let me double check. I don't think, Mr. DeBoos, that you have filed any kind of demand or request or notice for jury trial. Have you?
I thought that was entered into the last court session.
Well, I don't think you filed any motion. You told me apparently you told me you wanted a jury trial, but you never followed through.
I thought that was a decision that we made as the court.
Well, you and I did not make a decision of any kind. Mr. Patterson, do you believe it's acceptable for him to just say he wants a jury trial?
Your Honor, pursuant to case law, because there are at least up to 1 year in the county jail possible, if it's ever consecutive, then case law would state that he has a right to a jury trial.
Agreed, but does he not need to put something in writing to that effect that he wants one? That was my question.
Because there's an absolute right to jury trial, he would not have to put it in writing. It would have to be specifically waived by him, Your Honor, and I don't think he's done a waiver.
Very well. Do you agree with that, Mr. Regier?
One moment, Your Honor. Your Honor, what I can say at this time is pursuant to KSA 6238 subsection B, quote, on any issuable trial by right by a jury, a party may demand a jury trial by serving the other parties with a written demand, which may be included in a pleading no later than 14 days after the last pleading directed to the issue is served, and found the demand in accordance with KSA 6205 and amendments thereto.
Mr. Patterson, in spite of that statutory language, do you think he needs to waive his right to jury trial? Did I hear that right?
Absolutely, Judge. Pursuant to case law, and I don't dispute the statute whatsoever, but there is certain case law that makes it a constitutional right to a jury trial if the sentence would be up to a year in the county jail, and in this case, consecutively, it could be up to a year, the longest possible maximum. So it would have to be waived by him, and he would not have to make anything in writing to receive that.
But you don't believe that case law overrules the statutory law, or do you?
This is a constitutional right we're talking about, Your Honor. It would trump the statute.
Okay.
And Your Honor, I would note that pursuant to the information filed with the court in August, this case does appear to include 3 counts, 2 Class Bs, and an unclassified non-person misdemeanor. While it would appear that in this particular instance, subsection 2, pursuant to KSA 216602, quote, for purposes of sentencing, the following classes of misdemeanors and the punishment and the terms of confinement associated for each class are established. Class B, the sentence for which shall be a definite term of confinement in the county jail, which shall be fixed by the court and shall not exceed 6 months. So, given that my understanding is that neither a plea nor sentencing recommendations have been submitted to the court in this matter, it would appear that at least the issue raised by standby counsel is somewhat academic.
So, Mr. Patterson, when you say up to a year in the county jail, are you thinking if they were to be run concurrently, or I mean consecutively versus concurrently?
What happens if my dad starts Tai Chi tomorrow?
Be the longest possible sentence when you start running them consecutively, and that's what the case law would state.
Do you have your statutory site or your case law sites by chance? I know you didn't expect to pull them out.
It's not what I keep handy, but giving a short recess, I can find that.
Well, now before you go to that, now, Mr. DeBoos, do you have any idea what's going on here?
I, as a common man, do not comprehend the legalese that you guys are using together. I can look up statutes and case law myself, and considering that this is dealing with a common right to all people granted to us in restriction of government entities for the people itself, I comprehend that I have my right to jury trial, which I think Mr. Patterson, in his brief support towards this and towards me, towards my right to a jury trial, although I do not fully comprehend the legalese that is going on within the association between Jared Regier and yourself, Phyillis K. Webster.
All right, well, Mr. DeBoos, the point is you do have the right to represent yourself, and you've told me you want to represent yourself, and I've asked Mr. Patterson to stand by, and you've already used him here for this purpose. So here's the thing, Mr. DeBoos. No, let me talk now, Mr. DeBoos. Here's the thing. If you're going to represent yourself, you need to be able to make your own arguments. You need to be able to cite your own law. And if you cannot do that, you have the right to legal assistance, which is why Mr. Patterson is here. And you've already this quickly run into a legal snag that he's made the argument for you. Does it not make sense to you? And do you not want to have his legal assistance to let him represent you?
I do not wish to be represented by an attorney whose duty first is to the courts and not to their clients. And if we're speaking on rights in regards to laws and statutes, the arrest made on me by Deputy K. Barriquet was an unlawful arrest.
All right,
for
well, we're not going on
22-2401.
We're not going down that path right now, sir. We're not going down that path right now. Well, the issue is, so you do want a jury trial. Are you ready to proceed on Wednesday, Mr. DeBoos?
May I ask that there be an extension so that way I may fully research the procedures of the administrative criminal law which you're trying to try me under?
Well, I'm not the administrative law judge. That is yet another procedure.
Although you are in an administrative court under the state of Kansas Corporation, correct?
I'm here in a criminal traffic trial, and I am not an administrative law judge. So here's what we're going to do. How much time do you want this continued for?
30 days or so seems to be a standard.
Well, my next available jury trial date would be October 2nd and 3rd. So
2024.
2024. So that's when I will continue this at your request to. I'll grant your continuance, but that's my next available date. And your pretrial will be September 30th, 2024. Do you have any objections to that?
No objections. Let me write those dates down. You said September what?
The pretrial is September 30th, 2024 at 9 a.m. And the jury trial starts at 9 a.m. October 2nd and 3rd.
Both of those dates?
Both of those dates.
Okay. I would like to point out that the bond and bail I made on this arrest is an unlawful bond, considering that the arrest was unlawful itself.
Looks like Judge Crum set your bond on August 18th, 2023 at $2,500 cash or surety, and that will be maintained so long as, sir, you appear at every date and time you're required. Anything else, Mr. Regier, we need to take up on this matter?
Your Honor, if the court is granting the defendant's request for continuance, I respectfully have it noted for the record that this case at the next hearing will be over a year in age, as I understand it. So the state is not in favor of this continuance. So I would respectfully have that noted. Additionally, my understanding is that a motion in limine was filed by my office. And if the court is saying this matter for both pretrial and jury trial, I would respectfully reserve my rights pursuant to the statement and have the motion in limine be addressed at the pretrial hearing.
That the objection of the state to the continuance is noted. And yeah, we can take the motion in limine up.
Your Honor, if I may be heard briefly.
Yes, Mr. Patterson, please.
The motion that counsel talking about was emailed to me. I'm not the attorney of record, so I have not accepted service. I sent an email back to counsel, and I did provide Mr. DeBus's address that I had seen in the court system that they can directly mail that to, and I've just asked that that be mailed to Mr. DeBus for service.
And Your Honor, I am showing in my file an affidavit of service by first-class mail, and which would appear to include a mailing date of at the end of last week.
All right. Very well then. And if there's nothing further, did you get that, Mr. DeBus? Did you get the copy of the motion he's in reference to?
To what mailing address did you send it to, Mr.
Well, just tell me if you got it or not, sir. Did you?
No,
get
I did not.
Okay. All right.
In the Win with Zin sweepstakes.
Your Honor, one last thing. I did email to court counsel the copy of the case law about constitutional right to a jury trial.
Thank you, Mr. Patterson. I appreciate that. And Mr. Regier, he wants to know what you sent that to.
I'm afraid I do not understand the court's inquiry.
He wanted to know what the defendant asked, what address you mailed the motion to.
Your Honor, the affidavit of service I have in the file appears to be at an Andover, Kansas address.
Okay. Are you still in Andover, sir?
I'm in Wichita.
All right. Well, you have to keep the court informed of your address, or you're going to maybe miss more important documents. So can you send your current address to Mr. Patterson and Mr. Regier in the chat here without having to say it live over the internet?
I'm not for sure the address is going
I'm sending in the mailing address now.
Okay.
And Mr. Patterson, do you have any legal authority that suggests that I or that I reaffirm my oath for him? Do you have anything that says I should do that?
Judge, I'm afraid I've never researched that issue, never heard that issue.
All right, well, same here. I do have my oath in front of me. Keep it handy, but I don't see the need to repeat that. It was good enough for the Supreme Court of Kansas. Okay, so that takes care of Mr. DeBoose's case. You are excused, sir. Why should I give probation to a gentleman who may have violated the bond? Why should I think he's not going to violate probation in the same fashion? And because a police officer is involved, it makes me think that maybe the bond involves another battery or something. Okay, Mr. Patterson, who would you like to take up? Oh, wait, is there someone sitting at the jail? Who is that says sergeant that looks like he might have an officer uniform?
Your Honor, it would appear that in this matter, a subpoena was issued for Officer Sarchett in the Brandon Branscombe matter. I'm not sure if the court wishes to take that one up at this time or not.
Yes, yes, we should do that. I'm sorry, officer, to make you wait that long. Everybody's backed up here today trying to get it on the docket. Okay, so this is for Samantha Slater.
Your Honor, the state understands that Ms. Slater is also a subpoenaed witness in this case.
For Branscombe. Okay. We are on the record in 2025 CR 185, State of Kansas versus Brandon Lee Branscombe. Jared Regier for the state, Darren Patterson for the defendant. Please start your audio and video, and please find a spot to sit and not be moving around, sir. Can you hear us, Mr. Branscombe?
Yes, Your Honor.
All right, this is a motion to revoke or modify bond. The defendant is alleged to have had contact with a Danielle Erskine pursuant to Newton PD number 25-1121. And that would be in violation of the defendant's bond. I see we do have subpoenaed witnesses Samantha Slater and Officer Brett Sarchett of Newton Police Department. And I understand that Sarah Recheck, agent of Owens Bail Bonding Company, as well as the defendant and his attorney, were notified of the motion to revoke or modify. Mr. Florio is here for Simpson. Do we have anyone here from Owens for Branscombe? All right, Mr. Regier, do you wish to proceed on the motion?
The state is prepared to proceed, Your Honor. However, this does appear to be a case where the information was originally filed by my colleague, Ms. Norris. I understand there may be certain plea negotiations in this matter, so the state would respectfully inquire of counsel for the defense whether what the status of those are.
I'll accept.
And Judge, I would tell the court that I have discussed with Ms. Norris a way to resolve the case without taking up the motion. Based upon that, I believe my client is going to enter a plea of no contest.
Yes.
So you reached an agreement with the state to set aside the motion, but no one canceled the subpoenas. I suppose that's not all bad in case this no contest plea doesn't work out, but it would have been nice to let the officers know. Okay, so before I let you go, since you've waited this long, folks, if you don't mind just bearing with us a little longer. Mr. Branscombe, I'm told you're going to plead no contest to domestic battery, knowing or recklessly causing bodily harm to a family member or person in a dating relationship in Butler County, Kansas on April 16th of 2025. Do you plead no contest to that, or how do you wish to plead?
That's the If I understand correctly, that's the domestic battery, a misdemeanor.
That is a misdemeanor, Class B, alleging that on or about the 16th day of April 2025 in Butler County, Kansas, Brandon Lee Branscombe did knowingly or recklessly cause bodily harm to another person, to wit, Danielle Marie Erkson, a person with whom the offender is involved or has been involved in a dating relationship or a family or household member, as defined by subsection E in violation of KSA 21-5414A1 C1A, domestic battery, Class B person misdemeanor. How do you plead to that?
No contest.
By pleading no contest, you mean you're not admitting that you did this, but you don't want to deny it and take it to trial?
Yes, Your Honor.
Is anyone making you enter this plea today by threats or promises other than your plea agreement?
No, Your Honor.
Do you understand that with this plea, you'll most likely be found guilty,
Yes, Your Honor.
having waived your right to a trial and not able to appeal that conviction?
Yes, Your Honor.
All right, Mr. Regier, you have a factual basis to support this no contest plea?
Yes, Your Honor. Pursuant to the information, count one alleges that, quote, on or about the 16th day of April 2025 in Butler County, Kansas, the defendant Brandon Lee Branscombe did knowingly or recklessly cause bodily harm to another person who is identified as the victim in this case, a person with whom the offender is involved or has been involved in a dating relationship or a family or household member, as defined in subsection E. Were this case proceed to trial, the state's evidence would show the same. Additionally, the affidavit in this case does appear to refer to a past domestic violence disturbance at a location in Whitewater, Kansas. The state's understanding is that is within Butler County boundaries, as well as a reporting physical altercation between the defendant and the victim in this case.
You mentioned an affidavit. Well, the parties stipulate that if this were to go to trial, that affidavit would contain the facts that would be evidence in that trial.
Judge, for purposes of no contest plea, we have no objection to the court using the affidavit.
All right. All right. Based on the affidavit, I find there is a factual basis to support the no contest plea, and I do find the defendant guilty. Now, folks, apparently you've worked something out where these folks that have come in from Newton are no longer needed. The Newton officer and Samantha Slater are no longer intended to be called as witnesses. Is that right?
Your Honor, the state's understanding is that upon successfully entering a plea to count one in this case, the state would move in exchange to withdraw the motion.
These smart zooming blue light glasses will shock you. Nobody believed me at first, but now everybody wants a pair. My friends roasted.
So are you no longer offering that there was a violation of the no contact order? You're no longer alleging that the defendant violated this court's order by having contact with Danielle Erkson?
Again, Your Honor, the terms of the plea negotiation was that upon successful entering the plea, the state would be moving to withdraw the motion revoking the bond in this case.
Well, you may be withdrawing the motion, but it seems like if we're going to proceed to sentencing, this court needs to know or would like to know if the defendant violated its orders, because that could have an effect on any probation that is made.
And, Judge, I guess I will speak up. That is part of the plea negotiations between Ms. Norris and I, that that issue would become moot and not part of the recommendations.
And that is the state's understanding of the negotiated plea agreement in this matter as well, Your Honor.
Well, plea agreement aside, it's troublesome that a man can be accused of domestic violence battery to a Danielle Erkson, and the court can order that he have no contact with her. And I'm supposed to just ignore that and proceed with plea agreement. That's troublesome. Well, let's hear what your plea agreement is, gentlemen. sentencing recommendations from the state?
Yes, Your Honor. The state's understanding of the plea agreement in this case is that the state would be recommending a 6-month underlying sentence, the maximum sentence allowed by law for a Class B misdemeanor, as well as a 12 months reporting probation with court services, subject to all standard conditions consecutive to any other Butler County cases the defendant may be currently supervised on. The state would further be recommending all applicable costs and fees, that the court make a determination on the issue of attorney's fees, that the court not impose a fine, but that the court require a domestic violence offender assessment, and that the defendant be ordered to comply with all recommendations, that the court order no drugs or alcohol, and that the defendant be ordered to report today to court services.
Mr. Patterson?
Judge, we're asking the court to adopt the recommendations, including that the no contact order can be lifted upon him getting his domestic violence offender assessment and providing that to his probation officer.
And Your Honor, the state understands after further review of the file that that was also contemplated pursuant to the plea agreement in this case, Your Honor.
This Danielle Erskine, she's his sister, is that right?
Ex-wife, Judge.
Ex-wife.
Or maybe common law wife now. They have kids in common.
The kids, okay, they have the kids in common. Okay.
10 years
What?
together. I'm
You have
sorry.
10 years? You and
we
this
have
woman
10
have
years.
10 years? Okay. And 3 kids?
Yes, ma'am.
When was the last time you saw her?
Oh, the day that I was arrested.
And was that in, Newton?
Yes, Your Honor.
All right. Now, is this Officer Brett Sargent up here on the screen?
Yes, ma'am.
I suspect, though you weren't called by either of the parties, I suspect you have information about this defendant violating the court's order. Am I suspecting correctly?
Yes.
All right. I'm not going to put you under oath, but tell me just initially, informally, what the involvement is.
Judge, I guess I'd have to object, because if we're going to get into a full-blown hearing, I mean, that's one thing, but not to have the ability to dispute it.
Fine. All right, fine. Raise your right hand. You solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Mr. Patterson, I don't know what you guys have going on that you're trying to get around the courts knowing that he's been out violating court orders.
And Judge, that's disputed. I'm going to tell the court that's disputed. My client would suggest that he's not the one who had invited this contact, that it was not him, so it's disputed, but that's why we've entered into plea negotiations to avoid the confrontation of a hearing.
Mr. Regier, what do you have to say about not wanting the court to know that there may have been a violation of a domestic battery bond or order that could affect, and why it's important now is it could affect his success on probation? Why should I give probation to a gentleman who may have violated the bond? Why should I think he's not going to violate probation in the same fashion? And because a police officer is involved, it makes me think that maybe the bond involves another battery or something. And that's important. So, Mr. Regier, what do you have to say for the state on this?
All I can tell the court is that the state did anticipate proceeding to a hearing today. However, the state is eager to reach a resolution in this case, and all I am aware of is the terms of the plea deal as negotiated between my colleague and counsel for the defense.
Ms. Slater, how are you involved in all of this? Are you an officer? Are you a family member?
No, I witnessed a verbal-ish altercation at the end of April in Newton.
All right. Well, I am going to tell you both, I'm not going to sentence him to probation until I know what's really going on here.
Judge, short of getting into a long trial, which is basically what we're talking about, I can tell the court my client was not arrested for domestic violence event that day. Miss Erskine was, I understand, but my client was not.
Well, why can't Officer Sargent? Why do you have an objection to him saying that if that's all it was?
This robotic puppy looks so real, it completely fooled my neighbor who's a veterinarian. I've been a grandmother for 15 years, and this is the smartest purchase I've ever made. Last month, I got my granddaughter Emma this smart robotic puppy called Wuffy. I still can't believe what this tiny guy can do. This isn't just some stuffed animal. Wuffy has smart technology inside that recognizes Emma's voice and responds to her. He sits on command, barks when you talk to him, walks around the house, even tilts his head and wags his tail exactly like a real puppy. The first time Emma saw him, her eyes lit up. She cuddled him and didn't want to put him down. I could tell she felt calmer and happier than ever. She sleeps better now and smiles more than ever. Wuffy comes in two gorgeous colors, white and brown. I picked brown because it reminded me of my childhood pup. What I love most is watching Emma with him. When she pets his head, his tail wags and he makes these sweet puppy sounds back. It's like having a real puppy, but made from completely safe materials. 3 neighbors have already asked where we adopted him from. That's how realistic he looks. Emma treats Wuffy like her best friend. She reads him stories, takes him for walks around the house, even tucks him into bed at night. She's learning love and responsibility. Emma hasn't asked for a real dog since. I have to admit, I got one for myself too.
I think there's more here than what you guys want me to know.
I'm trying to avoid a long hearing, Judge, and get
Well,
the
that's
docket done.
fine.
That's exactly what that's a
Well,
purpose.
I'm all about avoiding long hearings that are unnecessary, but I am not going to shortchange somebody's physical well-being and put him on a probation if they've gone out and had another altercation while on bond when they were ordered not to have contact. I'm just not going to do that. So you guys can either have a hearing or I'll just order a sentence without probation. I'm not going to take a chance that somebody is going to get hurt again. And I'm not going to just ignore evidence that's right in my face. So you tell me, Mr. Regier, you're wanting me to do just that? You're wanting me to just ignore that he's apparently gotten into another domestic altercation with her when I ordered no contact? I'm supposed to ignore that? As officers of the court, can you genuinely recommend I do that?
Your Honor, may I request a brief 2-minute recess?
That would be fine.
Thank you, Your Honor.
Mr. Regier, if you're available, I'd like to reconvene. Mr. Regier, we are back on the record in 25 CR 185, State of Kansas versus Brandon Lee Branscombe, all parties as before. All right, folks, I set the bond as my responsibility. I set bonds. As my responsibility, I impose sentences. But before I proceed any further, I have to know what's really going on here. And both counsel have indicated that I shouldn't hear from this Officer Sergeant. But Officer Sergeant, do you have any information that this defendant violated the bond in this case, wherein I ordered that he have no contact with Danielle Erskine?
I do.
And what information do you have?
On April 24th of this year, we responded to a disturbance between a male and a female. Both the male and the female were located. I spoke with the witness who is here with us today. And she informed me that she watched a man driving a white SUV pull up into the alley near where she was parked. She saw the male exit the vehicle and begin screaming at a woman who was seated in the passenger seat. Upon locating both individuals, they were both identified, and they actually admitted that they had a no contact order in Butler County for a recent domestic violence arrest.
All right.
I also have another issue at hand. Last week, I reached out to the Butler County Sheriff's Office in hopes to get in contact with them to verify whether or not the bond conditions were
I'm
still
going
in
to
place.
object as hearsay, Judge, unless we have somebody from Butler County here.
I want to hear it. Go ahead.
I did that because I forwarded this case to the Butler County Sheriff's Office based on the information that the defendant had informed me of, that he had bond conditions. Last week, they were in contact again. We arrested.
Hang on. Who was back in contact again? The man and the woman?
Yes.
Okay.
So what he informed you earlier, that the last contact he had with her was the date he was arrested, and was untruthful.
Okay. All right. So the man and the woman in the truck, do you know who they were?
It was Brennan Brenscombe and Danielle Erskine.
Okay. I didn't totally follow the Butler County thing. You contacted Butler County and told them what you had in Newton?
I tried to. I asked our dispatch to send a teletype, basically an email to the Butler County Sheriff's Office, to have one of their deputies reach out to me so I could verify whether or not the bond conditions were still in place.
And the result?
They did not reach back out to me. They did not call me.
Okay. All right. Okay. Ms. Slater, please raise your right hand. Solemnly swear the information and testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right. Now, what can you tell me about anything that has to do with this Butler County case involving the defendant, Mr. Branscombe, and the victim, she's now determined to be the victim, Danielle Erskine? What can you tell me, if anything?
Sure. The only thing I can tell you is what I saw. I believe it was April 24th. I was in Newton for a work-related reason, but was sitting in a parking lot at the Dillons, and in front of me, a white SUV went into the alleyway that was in front of me, and I saw a gentleman exit the driver's side of the vehicle, shut the door, seemed flustered. I could not hear anything that was being said at all. I didn't have my windows rolled down or anything. I was just going off of visual. I could visually see that he was upset. He was yelling at the vehicle. And then after a little bit of time, I don't know exactly how much, he went to the passenger side. And then the passenger side door opened. He did not open it, but it did open. A woman got out. And then they were having a verbal altercation. They walked behind the vehicle, and then I saw her put her hand on his arm, kind of like a, hold on a second, come back kind of thing. And, he pulled his arm away, and he was still yelling at her. I couldn't really tell what her demeanor was, or her reactions or anything. She did have her hands up a little bit, kind of like, whoa, hold on a second kind of thing. And then he continued to walk. He did pass the car. She did get into the driver's vehicle, or the driver's side of the vehicle. They were kind of following each other down the alleyway. There wasn't a whole lot going on at that point. I could still see that he was, agitated. He was still yelling at the vehicle. They did stop a couple times. I never saw her exit the vehicle again after she had got out of the passenger side. And then they had come to a street. I don't know Newton super well, but they did come to a street. The back hatch of the vehicle opened, and then it closed. I didn't see if anything was taken out or anything like that. And then they did continue to drive down the street. And then when they passed, I believe it's Main Street in Newton, I couldn't really see them after that. I saw her pull into the Little Caesars parking lot, and then I was kind of done with it at that point. I couldn't see anything anymore after that.
I get dermaplaned every single week, and the lady at the spa
report that at any time to law enforcement?
Yes, I called 911 just shortly after she had put her hand on his arm.
All right. Thank you.
Yep.
Officer Sargent, you're the one then that took the report and worked it?
There were, I believe, 3 of us working that specific case.
Have criminal charges been filed against either party, Branscombe or Kirkson? Do you know?
Yes, both of them went to jail that day.
Okay, and do you know if the prosecutor filed anything formally yet?
That I'm not sure.
Okay, all right. Okay, well, thank you both very much.
Judge,
Now,
I have a question for the officer.
all right, go ahead, please.
Officer, you said both of them went to jail that day. What were the charges against each of them that they were arrested on?
I believe Brandon was for driving on a suspended license, and the Danielle was for domestic battery.
Okay. Mr. Branscombe was not charged with domestic violence or arrested for domestic violence at that time. Is that correct?
Correct.
That's all I wanted to clear up, Judge.
And let me follow up. Okay, driving while suspended against Brandon, and what did you say against Danielle?
Was for domestic battery.
Okay, all right. Mr. Regier, you have any questions of either of these two?
No, Your Honor.
Did you have any for Miss Slater, Mr. Patterson? Okay. Well, folks, I am going to take this all under advisement. Mr. Branscombe, your attorney may not want you to talk right now. I don't know. He wants to talk, Mr. Patterson. Do you want to let him?
I will talk with Mr. Branscombe later, Judge.
All right. I am going to set over the sentencing on this. Now, the problem is I'll set the sentencing over 1 week. I know I'm gonna squeeze another one on you. Can we put that at 1:30? 1:30 by chance, Jen, on Wednesday? No, that can't do that either. Never mind. Let's put it 9 a.m. Monday, and the defendant must be present at the Butler County Courthouse unless his bond is revoked. And at this time, I'm going to revoke his bond.
And Your Honor, Your Honor, as indicated on the record, the state has withdrawn its motion pursuant to.
I understand, and on my own motion. Mr. Branscombe, where are you at this moment?
I am waiting to enter into a inpatient facility. I've got my assessment and everything. My bed's waiting.
I didn't ask you what you are doing. I said, where are you? What town are you in?
I'm in Wichita, ma'am. Your Honor.
Wichita? All right. Are you in a residence? Are you in a treatment facility?
I am at a residence, and I'm waiting for the court to be done with so I can go into my inpatient. They told me if you guys needed to speak with them on the court's behalf, you need to speak with them to verify that, for me to give you their number, and they would verify that.
What are you going into treatment for?
For drugs and alcohol, Your Honor. I have an addiction problem, and I need to get it taken care of.
So you couldn't even report to probation. You're not even ready to start reporting to probation. You're going into treatment.
Yes, yes, Your Honor. I feel that getting myself.
How about batter's intervention? Have you done an evaluation for that yet?
No, ma'am. I started mental health and med management through Prairie View in Newton. And I've been working with CCRT. I don't know if you're familiar with them, but they're out of Newton, Harvey County. And they have, they also have the BIT program there at their location.
Okay, so you violate bond. You work out this nifty plea agreement with the prosecutor that you don't have to face any consequences for not only violating bond, but going out and getting into a confrontation with the victim.
hours.
And then instead of reporting to probation, you're telling me, or going to jail, as I could order you, you're telling me, well, I went out and I got myself into an alcohol and drug treatment program. Although the issue in front of this court is domestic violence, it probably is aggravated by drugs and alcohol. Counsel, I feel like you've brought me an impossible situation unless I just order the police to go out, pick him up, put him in jail, and let him serve 6 months. I feel like I have been manipulated to the utmost in this case, and that's not like either one of you two to do that to me.
And Judge, I guess I take offense to the word manipulation. These are standard plea negotiations that I've entered into with the state. So yes, have we entered into a plea negotiation that was to leave out information from the court? Yeah, that's just standard plea negotiations, and that the court has on its own retrieve that information. Well, this is Your Honor, this is your court. I can't really stop the court from doing that since the witnesses are right here. But I think it is a plea negotiation that was warranted and well thought out, and one that we presented to the court.
Well, and I appreciate your offense, Mr. Patterson, but here's why I see it as manipulation. You weren't going to tell me that he was having contact with this victim of abuse. You weren't going to tell me that he was screaming and yelling at her to the point that a citizen called law enforcement, and law enforcement came. You weren't going to tell me that he was seen driving while his license was suspended, which is a violation of the law. Bond says don't violate the law. Bond says don't have contact with this woman. Then when I get to sentencing, you've got him signed up to go into an alcohol and drug treatment program that nobody told me about, but it would circumvent reporting to treatment. And what about that statute that says he has a mandatory 48 hours and a mandatory $200 fine, which I can waive if he does the BIP intervention?
What is an SOP? So here's a misconception. A lot of people think an SOP is just a boring manual that nobody ever reads. But that's not true at all. SOP stands for Standard Operating Procedure.
But he's not set to go into BIP right away. He's set to go into alcohol and drugs. That to me looks like manipulation so that he doesn't have to serve his sentence, that he doesn't have to have any consequence for violating bond. Manipulation that he doesn't have to have any consequence for what happened in violation of the law while he was on bond. I mean, driving while suspended, that's a B misdemeanor, a crime. And I'm not supposed to know about any of this. Let's keep the judge from knowing this. Mr. Patterson, that to me looks like manipulation. Maybe it's not. Maybe you don't see it as that. And I respect you as an attorney, and I have for many years, and I respect Mr. Regier as an attorney. And I have for not as many years because he hadn't been at this as long. But this is highly troubling to me that I'm seeing this. And if this is standard, and I haven't seen it before, and I'm being duped by it, that's alarming. Because judges are supposed to know what they're dealing with when they make a sentence. And how's Mr. Branscombe going to deal with this? Again, this is outside of my jurisdiction, but at the same time, what he does in other jurisdictions should affect what he does in this court on probation or as such. But if he's facing driving while suspended charges, but he can't go because he's in treatment.
I don't know that he is, Judge. I haven't seen any charges filed in the city of Newton.
Fair enough. Fair enough. And I know that if they need alcohol and drug treatment, that's a very big, important priority, unless it's designed as manipulation to skirt consequences. Was there even an evaluation, or did I understand him to say he just went and signed up for it?
Judge, I can tell the court this was the treatment program was not part of this case or part of the negotiations. That is something he's doing on his own. This is the first I've heard of it. The batter's intervention program, on the other hand, is something that was part of the plea negotiations.
Mr. Branscombe.
Yes, Your Honor. I just want to say that I did get a evaluation. Actually, I got several of them over this last about week and a half to try to find the earliest opening bed that I could so I can get into treatment sooner than later. And the one that I found was supposed to be today at 9 o'clock in the morning. I had court at 9, so they extended it till 1. But I have another. They said that it would be okay if I came in tomorrow. If it doesn't work, they told me to give the judge their contact info and that she can contact and talk to you and tell you about how I came about getting there and everything else. I'm not trying to manipulate you, Your Honor.
Mr. Branscombe, this allegedly occurred April 16th. Well, this did occur because we found you guilty. April 16th, 2025. What motivated you between then and today, June 9th, 2025, to go out and get this evaluation?
Well, the loss of my children that were taken from me and my wife not being able to have contact with each other.
But you have been having contact.
I have. I'm not going to completely lie to you, Your Honor, but it hasn't been like it was. Like we're a family. We live together. We're with each other every day. We're a family. We have a business together, and it's gone from all of that to, and all of a sudden, in one waking moment, my children were taken away. I wasn't allowed to be told where they were. My wife was. I was told I couldn't have contact with her. So there goes my work because I don't have a valid license. She was the one who drove us, and she was my helping hand in our business. I mean, we have a LLC. We've been open for 3 years, and it's just all of these things were just all at one time. And I just came to the realization that when we were clean for 7 months just recently, we got off the drugs and we were clean for 7 months. We didn't argue one time, Your Honor, like not one fight. I mean, nothing. And it was awesome. It was amazing. And then we relapsed, and things got worse and worse and worse. And I recognize what it is, and I know that I can't get my family back without me getting myself clean. And it's been on my heart and my mind that I've been thinking about it over the last month and a half, 2 months, and it's time. I want my kids back. I want my family back.
Did you make this appointment after you had contact in Newton with law enforcement?
Yes, Your Honor.
So it wasn't the domestic violence in this case that was the final trigger to make him do the appointment. It was the second contact.
Yes, it's just that it wasn't the domestic.
It wasn't the domestic. Go ahead.
It wasn't the domestic per se. It was just me coming to the realization my family's been torn apart and being held away from me, and it's all due to my usage and being an addict, and I wanted to get it fixed and get it right. I don't want to lose my wife and my kids.
Are you researching dental implants?
There's a lot of dental offices that'll talk.
Saying all the right things.
Well,
Okay. When's your next available bed?
Today.
What time?
It was at 9 o'clock, but they said they can push me out until 1 o'clock.
1
for them
o'clock.
today. Yes, ma'am. And if I can't get in there by 1 o'clock, that they want to be able to get me in through the rest of the day. That tomorrow morning to be there at 8.
This is alcohol and drug treatment. What was the facility?
It's Cherry Creek.
Cherry Creek. Okay. And it's in Newton?
No, this is in Wichita.
And it is inpatient for how long?
I believe it's a 30-day program.
You don't know?
I haven't got all the fine details. I mean, they sent me the pamphlet.
You were going to go check into this facility without even asking them how long the program was?
I need it, ma'am. I mean, if it's 30 days, 60 days, it really don't mean a lot of difference to me as long as I'm getting what I need to and getting some clean time back under my belt and getting back out here for my family.
Well, I cannot tell you how many times I have seen someone who gets into your position use treatment as a hiding, as a manipulation, as a way to avoid consequences. Whether you're doing that or not, I don't know. You sound, like I said, you're saying all the right sounds or words. You've got the right inflections. I am going to withhold your sentencing until you complete your treatment, but it better be inpatient.
Yes, Your Honor.
And you contact the attorney as soon as you get close to your out date.
Yes, Your Honor.
And I'm going to get you right back in here as soon as possible for your
Yes, Your Honor.
sentencing.
Yes, Your Honor. Thank you.
Is everyone clear on that? We'll
And Judge,
continue.
I guess what I'd ask him to do is when he goes to the treatment facility, that he have them send me a report stating he's admitted and what his out date will be. That way we know a little bit sooner than just when he's released.
Yes, do that because Mr. Patterson, then if you'll get that to me, I'm going to set the hearing in relation to when the out date is set to be so that I don't just drop the ball waiting for him to contact us because we know that would not be a wise decision.
Yes, Judge.
But but in the meantime, I'm still going to set a date, just a control date, Mr. Patterson, but I want to change it. What do we have, Jen, about 30 days out?
One moment, Your Honor, I'll look.
Okay. And it could be that if it's a 30-day treatment program, we may end up getting lucky and setting it now, but. And why isn't the victim here, Mr. Regier? Did she have notice of this hearing?
One moment, Your Honor.
I'm going to, Officer Slochet, Ms. Slater, you are welcome to stay to the outcome, or you're welcome to go. We've used so much of your time this morning. I want to thank you for being here. I want to apologize that you've had to wait so long. But I'm going to leave it up to you if you want to stay or go.
Thank you.
You're welcome. Thank you.
Your Honor, the state's information is that there has been contact between the victim and my office as recently as within the last 2 to 3 weeks.
Well, make sure she's given notice of this next hearing. It would be helpful to hear from her. Okay, Jen, did you find a date about 30 days out?
One moment. We have some room on July 7th or July 21st.
Let's see. Let's go with July 7. That's closer to the 30-day mark. July 7, 9 a.m. This matter is continued for sentencing unless, Mr. Patterson, you find out something closer. I don't want him out before I see him again. I don't want him, but you are still on bond. You are not to have any contact with her, Mr. Boneskin. You are not to violate any laws. You're muted, sir.
Yes, Your Honor, I understand.
All right. Anything further from anyone?
No, Your Honor.
Not from the state, Your Honor.
Thank you. Get to treatment. You better be there at 1 o'clock or it's a violation of your bond.
Yes, ma'am.
All right. And get proof to your attorney.
I finally solved my rat problem.
Illegal commit me to a hospital?
Mr. Hammond.
I'm sorry, Judge, I didn't hear you.
You have just one case on John Hanna today?
Yes, Judge. Yes, Judge, just one case.
We are on the record in 2024 CR 420, State of Kansas versus John Raymond Hanna. Please announce appearances.
Jared Regier on behalf of the state.
Your Honor, Darren Patterson, appearing on behalf of John Hanna. Mr. Hanna does appear via Zoom audio-visual from the Butler County Jail. Judge, this is a case where I am requesting the court to allow me to withdraw. I would just tell the court that communication has broken down to the point where counsel and client are not able to discuss the case any further, and would ask substitute counsel be appointed, or Mr. Hanna may hire counsel. I don't know.
Mr. Hanna, are you able to hire counsel?
I'll have to look into it, but I'm pretty sure I can figure something out.
Well, if you can hire an attorney, you should hire your own attorney. But you apparently told me or someone else that you couldn't afford an attorney early on, and you received court appointed.
No, I'm saying that I have been in court. I've been pretty much in a situation where I was supposedly incarcerated, to where I haven't been able to contact my family members. What I explained. That's how I explained that. I don't like contacting my family members from facilities like this. Because I had problems stealing my mail and identity theft, so I don't really don't talking to my family member and giving out addresses in situations like this with these people who don't have what they call a 922E or a 912E jurisdiction. So we can continue on if you want to try to. I just jurisdiction right now.
Well, what in the world is a 912E jurisdiction?
I'm the judge. You're supposed to figure it out. I'm telling you for.
I can't figure out something that doesn't exist.
It does exist, but I'm saying if you don't exist, I understand. If you don't know, I mean, it's not my fault.
Well, it is. If you're going to bring something up that I'm not familiar with, you're going to have to tell me what it is.
No, it's jurisdiction. I mean, you have to look it up. You hired a counsel for me. You hired a counsel for me, and this dude is over here like supposed to be the. I mean, and then and the other thing, dude told me that the court that he said it was going to be 3 days from now. He didn't say it was going to be today.
Who told you that?
He did. The attorney did.
All right, Mr. Regier, do you know what this? Tell me that number again. What is that number you're citing, sir, for jurisdiction?
922E.
920.
And you got a 912E too.
And a 912.
Yeah, that the corporate courts are illegal in the United States, pretty much.
Corporate courts are illegal.
Pretty much illegal in the United States, yeah, pretty much.
Okay, that's
on the Brady violation as well. Maryland versus Brady.
I know Brady.
Yeah, Maryland versus Brady, yeah. And when we addressed this issue, you should have started with Maryland versus Brady. When you addressed me before anything, you're supposed to address me with Maryland versus Brady.
All right, stop it right now. I'm not going to keep taking your abuse.
Okay, I'm not going to take abuse. I don't want to lock no handcuffs on.
All right, you're going to stop it. You're going to sit him down, and you're going to show respect for the court.
It's my house.
Stop it right now.
I built it, whatever. I'll pay down this bill.
You will stop it right now. I understand we have a screen between us.
Yeah, okay. I know we have a screen between us. I don't even know if you're in the courtroom for real. Let's do a video.
Well, I think I understand why Mr. Patterson, a very experienced, very competent, qualified attorney, can't work with.
I got a couple of them too.
Well, if you got them and you can afford them, there's no reason the taxpayers ought to be paying for your attorney.
I'll pay. What do you mean? The taxpayers ain't paying for my attorney. Point blank. Quit telling my intelligence, please.
Well, I'd order them to take you into custody, but you're already there.
I know I'm in custody, and you went up on my bond in custody. How you do that? Oh, that's what Department of Justice right there. Thank you. Are there any more things to issue, Mr. Jay? What's the prosecutor's name?
You don't address me. You're stop it. Mr. Patterson, you are most definitely excused from this case for the reasons cited. You may journalize the dismissal.
Yes, Judge.
And I don't see any need to point anyone else because the defendant's telling me he can afford an attorney. You just need, what do you need to hire your attorney?
Let me figure it out and I get to it. I don't like to make rush decisions, especially in handcuffs.
All right, Mr. Regier, have you ever heard of this?
Thank you.
What he's talking about?
Him too.
Stop talking. Do you, Mr. Regier? Mr. Regier, do you know what he's in reference to when he says 922E jurisdiction and 912E jurisdiction?
Wrote that down backwards.
Judge, I think those are pursuant to federal rules of procedure.
Well, we're not in federal court, so I don't keep myself.
But you have to go by my constitutional rights for a due process. For to be a corporate court, because you're financed by federal money. You're not this is not financed by the people here in this county. You get government grants to run this place from the feds.
Where in the world did you hear that?
It's the truth.
Where'd you hear it?
I don't matter what I heard, because I do my own research. I'm not answering that question. I would plead the fifth on that question.
Well, I don't know what he's talking about. Exactly. It's a federal rule, but this is not.
So we can bring up the competency of the court right now. We'll have to turn just on that. Do we need any issues, Mr. Prosecutor? The Department of Justice will be emailing you pretty soon.
Sir, let me explain something to you. You are in the district court, 13th Judicial District.
For misdemeanor accusation.
State of Kansas. This is not federal court.
I understand federal court.
The rules that apply are the Kansas statutes annotated. Yes, the Constitution applies, but you're not citing Constitution. You're citing apparently federal rules of evidence that apply in federal courts, not in Kansas.
No, that doesn't apply in federal court. It applies to a state because it goes with Maryland versus Brady.
Where did you get your law degree?
You don't have to have a law degree. Doesn't matter about that because I've been educated by the best attorneys in the United States. One of them is I happen to be real close to one of their daughters, a few of them, and their sons, and their sons. And I personally know a U.S. Supreme Court judge as well.
All right, so Mr. Patterson is allowed to withdraw, and that's at your request, Mr. Hanna. You want him off your case, right?
Definitely.
All right, so this time is going to count against you so that you can get a new attorney. And you told me you are going to hire your attorney. Is that right?
Yeah, I said I will figure it out. Is what I said.
All right, so you'll figure it out. You don't want the court to address another court appointed, right?
Pretty much not. Not with that competency level.
Not a court appointed attorney.
Introducing the only prescription hair regrowth gummy on the market, the Minoxidil Plus Bio.
Have the notes reflect he does not want a court-appointed attorney. He questions the competency level.
I want to go after the prosecutor now.
Oh, you want to go? You said you want to go
against prosecuting. Thank you. Stay put that on the record. Terry Fire got on paper. Thank you, Mr. Prosecutor.
So what did you say? You want to go after the prosecutor?
No, I said we will holler at the Department of Justice. We'll talk to him. Go after his accusation. Is what I said. Confirm his accusation with the Department of Justice. That's what I said. Thank you. Is there anything else I can get back to where I was legally incarcerated at?
Deputy, do you think that does he normally behave competently? I'm wondering if I need to do a competency evaluation. Anyone want to be heard on that?
I've already had one.
In this case, you have?
No, I have one on my federal case. I felt competent because everything I stated with it, it's already backed by law.
Well, I am going to, on my own motion, order that there be a competency evaluation. That can be done in the county jail because I'm not sure you're tracking, Mr. Hanna.
Good for you. I don't care if you think that or not because I can decline it. I can decline that. And if I'm found incompetent, that means you can't do what? You can't put me in a court of law. So you just made another mistake.
Well, if you're found to be incompetent, you will go to a state security hospital.
No, I'm on it. You can't legally commit me to a hospital.
Yeah, I can.
No, you can't.
There, yes.
No, you can't. That just goes to show you try to commit me to a that's illegal. You can't do that either.
Well, he's set for jury trial this week. I'm going to continue the jury trial because he needs a new attorney. The time will count against him.
So how do you do illegal commits, take people's property, identity theft? Yes.
And we need to do a competency evaluation. We will set this over. When's my next available jury trial date, Jen?
February 23rd for the pretrial, February 25th and 26th for the jury trial.
You said 26, and did you say 25 and 26?
That's correct, Your Honor.
Okay. All right. So the defendant is ordered to be here February 23rd for pretrial and February 25th and 26th in person for a jury trial. And then when I get the motion on file for competency, then we'll set the competency hearing before then, of course. I see you have had a U.S. Marshal hold on federal charges. That was back in April of last year. I see there was a previous failure to appear.
I was in Butner on evaluation because I had to get rid of the last attorney I had. His name he was going under a fake name. His name was Kurt Burrows, and his name was Beeman Howard. So I had to remove from my case because he wasn't even who he said he was.
Well, I don't know.
Party mistake. Yes, conflict of interest. Yeah, I've had to remove from the case.
Well, I don't know either of those names. That must be on your felony charges.
Yeah, felon possession firearm, which I got a settlement on. Then I got a settlement when I was in federal prison for it. Got a settlement for it. I've been illegally detained. It's in the law book.
And I see your first appearance, 9/6 of 24th. You were found to the court at that time. I think that might have been Judge Satterfield. I'm not sure. Found you very combative and challenging jurisdiction even then. Oh, it was Judge Sanders. That was retired former Chief Judge Sanders. Okay, former Chief Judge Sanders. All right. Well, I think everything is resolved. Anything else, Mr. Regier or Mr. Patterson, we need to address on this matter?
Your Honor, more of a point of clarification. If the court is ordering a competency evaluation, the state will be requesting clarification as to who has prepared the appropriate journal entry.
If your staff has those forms available and wants to do that, that would be fine. If not, I'll have to do it myself.
Very good, Your Honor.
And Judge, I'm out of the case, of course, but I think Mr. Regier knows that it's supposed to be the local mental health department that does the initial evaluation.
Yes.
The state is well aware of that, Your Honor.
Thank you.
There's conflict of interest. He doesn't want interest.
Where's the conflict of interest, sir?
The prosecutor cannot give me he cannot be the one that gives me a competency hearing because he doesn't have he's the one accusing me of something. He's the one that brought the charge, so he can't be the one in charge of my mental competency hearing because it's a conflict of interest. It has to be somebody who has my interest.
Well, I don't have your
or somebody that's objective to it. Objective point of view, it can't be him.
Okay, well, I'm the one that is ordering the competency evaluation. He just has the staff to do the paperwork, but I'm the one ordering it.
Okay, so you shouldn't have said that though. It's on record.
All right. Well, all right. That's the order. And deputy, please, I'm remanding him back to your custody, the custody of the sheriff, to take him back wherever you need to take him.
Thank you, Your Honor.
You're welcome.
Okay.
Judge, we have two more in custody. Cheyenne Pamp.
Okay.
Okay.
Nice.
If you live in an Alabama zip code,
heinous.
As 2023 TR 1225, State of Kansas versus John Kelly Ernest. Jared Regier for the state, John Kelly Ernest in person, and pro se. Mr. Ernest, that is you at Court Security 4, isn't it?
It is. Yes, Your Honor.
All right, we are set for trial on the one count of driving under the influence of alcohol dating back over a year ago to March 25th of 2023. I believe the county attorney did issue a number of subpoenas for today. Are you still wanting your bench trial, Mr. Ernest?
I was able to, well, because of the lack of understanding, I had a failure to appear and I was held over for roughly 30 days. But I did tell at that last hearing, the judge, that I would like a chance to secure an attorney. I met an attorney middle of last week, Gearing and Levitt is their name, Ryan Gearing. He was not able to attend today, but he did advise me that my best course of action was to apply for diversion immediately. So I would like to do that. I don't know how to do that, but
okay. Here's the deal, Mr. Ernest. You were here. You were supposed to have appeared for your first appearance March 31st to 23, and you didn't. So a warrant was issued with a $5,000 cash surety bond.
Your Honor, if you look, I actually was late that day. I did actually appear.
No, March 21st, or March 31st of 23. I'm not talking 24. I'm talking a year ago. March 31st, you failed to appear. Then on April 3rd of 23, still over a year ago, you contacted the clerk, said you were having link issues. Something to do with the docket being with Judge Satterfield. You were told that the county attorney was going to hold off on filing the bench warrant issued on the previous Friday, and you were to appear that day, April 3rd, with Judge Crum. April 3rd, you did appear pro se. Before Judge Crum, you entered a not guilty plea. And you told the judge then you were going to hire an attorney. So a year ago, April 3rd, a little more than a year ago, you told Judge Crum you were going to hire an attorney. Then 2 months go by, June 5th, you came in and you needed more time to hire your attorney, June 5th, 2023. August 28th to 23, you waived your right to counsel and said you'd like to apply for a diversion. You were told by the court if you wanted to fill out an application for court-appointed counsel, you could do so. And you said no, you wanted to apply for diversion, and the matter was set for bench trial on November 29th of 23. November 29th, 23, the bench trial was announced, but you failed to appear again. So a no bond hold was placed on you. February 28th, 24, you'd been picked up on your second warrant and appeared before Judge Rickey. And he set the matter with Magistrate Judge Lee for March 22nd, 2024. March 22nd, 2024, you did appear on Judge Lee's expedited control docket. You presented by Zoom from the Butler County Jail. You told the court you were unsure if you would get an attorney or represent yourself. You were not able to contact anyone from your phone. And the judge reset the matter today for bench trial with me.
Yes, Your Honor.
Telling you you must appear in the courthouse in person. Are you in the Greenwood or the Butler County Courthouse?
Yes, ma'am, I am.
So it looks like we've gone a year and a week and we've just run a complete circle.
I understand, Your Honor. The financial difficulties I've gotten some help with. And that was the reason why every attorney that I talked to then.
Never sue the other driver after a car accident. There's a better way to get paid away.
Just couldn't find a way to afford it.
That's why I encouraged you to apply for court appointed, but you didn't want to.
I understand.
So are we going to do this for another year where we just run the cycle again?
No, Your Honor. I do not. I want this behind me. I've said that before, and 30 days sitting there having time to think about it. The situation that I was in, I did not enjoy. I'm sure you understand that. I want this behind me, Your Honor.
Mr. Regier, you were at that last hearing before Judge Lee. Were you?
Your Honor, my notes would appear to indicate that I was. It would appear that Judge Lee had set the matter over to today's date and time, after which the defendant appeared pro se as he does today.
Do you know why Judge Lee didn't dispose of the case then, or why he set it back here for trial? Can you give me any insight as to why I feel like I'm just going back to square one again? With the defendant saying he wants a diversion, he wants to hire an attorney. That's what he told me a year ago. Any insight you can share with me?
Unfortunately, Your Honor, I am not in a position to advise the court as to that at this time. Perhaps that question would be better directed towards the defense.
So what did you tell Judge Lee that made him set this for trial today? And why are you not ready to proceed for trial? Or are you?
Your Honor, Your Honor, he was pretty insistent that he believed that if I was going to proceed with a trial, that I should be represented. That if I insisted that I didn't want to, but he strongly advised me to get an attorney. That's why I spoke to 2 more attorneys and I got some financial assistance. And the advice that I got when I met with that attorney, that second attorney, was that absolutely I should apply for diversion. This is my only DUI, and that he can't see any reason why I shouldn't be approved for that. So I'm certain that I probably should have done that originally.
Why was Judge Lee and Mr. Levitt more convincing than I've been throughout the year, telling you you needed an attorney, I would appoint you an attorney?
That's a good question, Your Honor. I don't know. I've been going through a lot in my life and maybe obviously not making very good decisions. But having friends give you advice and tell you things is one thing. Having you tell me what is, I'm certain, good advice, turns out that it is good advice. I guess I can't explain it beyond what I've already explained. I just was not in the right place mentally and just really didn't know what to do. I was kind of frozen up, Your Honor, to just all I can do is be sincere. But I'm pretty convinced after talking to that attorney that I would be approved for diversion, and that's what I should do.
Well, Mr. Regier, do you grant diversion to somebody that's been telling you for a year he's going to apply and doesn't? Is that still an option?
Your Honor, at this point in the matter, I could not say. What I can say is that my notes would appear to suggest that the matter was set over to today for bench trial. My understanding is this is my colleague, Mr. Sweeney's case. If the case is to proceed to trial, the state will be requesting a continuance. As I understand it, there is an issue concerning witness availability.
So you don't have your witnesses here, which I couldn't expect you to have had them served within a week anyway. Or, well, it wasn't a week, it was March 22nd. So it's about, 2 or 3 weeks. And it does look like subpoenas were filed a week ago today. Trooper Hill, is Trooper Hill here? Don't see Trooper Hill. KDHE breath and alcohol subpoena. Master Trooper Grunder. Butler County intoxilizer. All right, so you're telling me that you need a continuance to apply for diversion or to hire an attorney or both?
I have already hired the attorney. He just wasn't able to be here today because that was only middle of last week. But he did tell me that I should apply when I'm in the building, which is right now, for diversion. If I can get that paperwork right now, I'll fill it out right now.
And the state has no objection to the continuance or the application for diversion, Mr. Regier?
Your Honor, at this point, with the preface that I do not appear to have an entry of appearance in my file with respect to Mr. Levitt, the state does not object to solely to the issue of a continuance. At this point, as previously indicated, my understanding is there is an issue of witness availability, at least insofar as today is concerned, as my notes would appear to suggest that today's setting was previously for bench trial.
Okay, Mr. Regier just raised an excellent point. This attorney that you said you hired hasn't even committed to this case. He has not legally filed an entry of appearance, which indicates he would represent you. What's that about?
I don't know, Your Honor.
You gave him the amount of money he said he wanted?
Yes, I gave him a down payment, yes.
A down payment. Did he say that that would be enough for him to enter?
Yes, he said he would be able to represent me, but he wanted me to show today to apply for diversion.
Well, that's not the way it works if you've retained an attorney, and certainly Mr. Levitt of all attorneys knows that. So here, I'll just be candid with you, sir. With what you've done this past year of delaying this DUI, I fear that you think you may have hired Mr. Levitt, but you may not. You may have made a down payment, and he may need certain other payments or requirements before he enters this case, and you may not come through with those. So we may just be starting all over again.
This robotic puppy looks so real, it completely fooled my neighbor who's a veterinarian. I've been a grandmother for 50.
I will do both things. I will apply for the diversion. I'll fill that paperwork out today, and when I leave here, I will call them and find out if there's something that I didn't honestly, Your Honor, I didn't even realize there was something if other than showing up, I didn't know whether there was something for them to do to recognize that.
Well, I'll guarantee you, Matt Levitt knows that. He knows how to enter a case and get a defense going. So that's why I'm thinking maybe you two didn't have a meeting of the minds yet. But the state's not set for trial because they couldn't get their witnesses in time. Apparently Judge Lee thought it's more appropriate to send this back to me and start over again where I was a year ago with you. How much time do you need to continue this, sir?
You're asking me, Your Honor? I'm
Yes,
sorry.
Yes, I am.
Probably only a week or two. I mean, I would like to fill out the diversion paperwork right now.
Now, here's what Mr. Regier usually tells me. He usually says, if the defendant is represented by an attorney, any application for diversion has to be presented by the attorney. Have you talked to your attorney about him representing you in the filing of diversion? Or did he just tell you to represent yourself in filing for diversion?
Yeah, he says since he had a conflict today, I was told to show today. Obviously, I had to do that and apply for the paper and fill out the paperwork for the diversion and submit it myself.
Mr. Regier, are you okay with that? That's not what you usually indicate you like to do. But he says he's represented by an attorney, but yet he's supposed to turn in his diversion on his own. Is that acceptable?
Your Honor, what I can say is, again, in my role as prosecutor, I do not represent the defendant in these proceedings. The state's understanding is that if there is private representation, communications from an ethical standpoint, if for no other reason, should be made through that attorney.
Well, I'll let the three of you, Mr. Regier, Mr. Levitt, and the defendant figure this out. Mr. Ernest, I really don't think you should show up again without an attorney when you told me you're going to hire one. I just don't want us to go in a circle again like it's been doing.
I hear you, Your Honor.
Now, if you get diversion, you won't even have to come back and see me if you do it in a timely fashion. You'll be diverted from the court system.
I will fill it out today, Your Honor. Like I said, I want this. I really, truly need this behind me. I would like to proceed with my life.
So you'll need time to apply for diversion, and they'll need time at the county attorney's office to study it and run your record and see if you qualify. And then they'll need time to send you a contract for diversion. And you will need time to, I would think, get with your attorney and go over it and sign it and get it back to the county attorney.
Okay.
So you're going to probably need more than just a week or two.
Your officer here in the courtroom just handed me some instructions for doing an application online. So I guess that's how I'm supposed to do it. So I will follow these instructions to the letter.
I don't know. I don't represent you, and I don't know what those documents are. And I hope that the officer has given you what it is you need. Now, don't look at the officer like he's your attorney. He's not going to be held accountable if he didn't give you what your attorney wants you to have.
I understand.
He's trying to be a good guy and help you, but if you have an attorney, you need to address that with your attorney. I'm going to say will he need an alcohol and drug evaluation if he's approved for diversion, Mr. Regier? Or can he get the diversion and then do the evaluation? Because that's going to depend how much more time I have to delay this.
Your Honor, the state's understanding is that drug and alcohol evaluations are typically required in these types of situations.
So you may, that's going to be something else you need to do.
Okay.
I cannot imagine Mr. Levitt just saying, I'll represent you, but then he leaves you hanging here. That's just not the way he works. Okay, we'll set this over somewhere, Destiny, between 30 days and 6 weeks, since he's got to get an alcohol and drug evaluation.
Are you wanting to put it on the bench trial docket, Judge, or just the traffic docket?
Put it on the traffic docket, I guess.
July 3rd.
July 3rd. That's our first available 9 a.m. Monday.
I can also squeeze him in on June 26th if you'd rather that, Judge.
But these are Monday dockets you're giving me.
Oh, no, I apologize. Sorry. June 24th.
I'm going to take him at his word that he's got an attorney, so I'm going to put him on Monday, June 24th. Although he's told me things in the past that have not come to fruition. June 24th, 9 a.m. You and your attorney better be here. Unless
Yes,
you
Your Honor.
apply for and are granted diversion, and you do everything you need to get that diversion.
Thank you, Your Honor.
You're welcome. I'm just hoping that you didn't get any more DUIs in the year that you've been out there unaccountable for.
Thank you, Your Honor. I appreciate it.
You're welcome. I'll continue the bond you're on with the conditions that you reappear June 24th, 9 a.m., that you drink no alcohol, take no illegal drugs, do not drive unless you're legally able to do so, and your vehicle is legally insured and tagged and registered.
Absolutely.
Anything further, Mr. Regier?
Nothing from the state's perspective, Your Honor.
Thank you. Mr. Ernest, you still, for all intents and purposes, are unrepresented in this case.
I hear you, Your Honor.
Until your attorney enters his appearance, you have no attorney.
All right.
So you better get back with him and talk to him and make sure you understood what he told you. All right, we'll be in recess. Thank you.
Thank you.
You're welcome.
I actually have gone to therapy.
One, Judge, this is a case where after talking with Mr. Swank, we are asking to have it set for a jury trial. Further, Judge, I would tell the court the named alleged victim in this case, who is Angela Brown Judd, was just in my office. She is wanting to appear here today. We did give her the email for the Zoom link. I don't know if she's appeared in the waiting room or not. I think she wants to appear in reference to a request to lift the GPS unit and also lift the no contact order.
Okay, Jen, have you seen someone identifying herself as Angela Brown -Judd, Judd?
I do have someone in the waiting room labeled iPhone. I have sent them a message, but they have not responded.
That's probably her. I'm not sure how good she is at the Zoom stuff, Judge.
Well, you know why we have this rule, Mr. Patterson.
I do. I understand fully, Judge. I don't know if the court wants to put this to the hill of the docket or.
Well, let's take a chance, and I'll have to bear the brunt if it's a mistake to do so. And of course, I'll come back on you, Mr. Patterson, as much as I have to answer. So
All's on me. I understand.
all right. So Jen, take a chance and bring her in. I don't know why they won't identify when they're told to, but. Okay, is Angela Brown Judd present? I'm still not seeing her.
Yes.
Are you?
That
Okay,
is her. That is her, Judge.
okay, you're Angela Brown Judd, is that right?
Yes.
And you are appearing today as an alleged victim in state of Kansas versus Justin Dannon Swank, is that correct?
Yes, ma'am.
And he is charged with theft of a truck and key rings belonging to you and criminal damage in a value less than $1,000, in which you're the alleged victim.
Yes.
These crimes allegedly occurring April 17th and 18th of 2025. What is it you want to be heard on, please?
Well, I know that
Before you answer that, excuse me, before you answer that, what's your relationship, if any, to the defendant?
That's my husband.
He is your husband. Okay,
Yes.
was he her husband on April 17th and 18th of 2025?
Yes.
All right, so go ahead, please.
Okay, so I kind of explained I do have some mental health problems that have been addressed most of my life. The issue with Justin is I acted out. As far as the truck's in his name. He does have the title in his possession. I have a brand new $1,400 iPhone that I'm holding in my hand now. And it was probably more of my fight on dropping the phone. The phone wasn't even worth $100, honestly, when we went and put it in a machine. So, I just don't. There's the truck's in his name now. It's his possession. I don't know any further. I mean, he is my mental health. He's over me with my SSI, my Social Security. He is
He's
my
what they call
caretaker.
your payee. He
He's my
gets your money.
payee and my caretaker. It's my mental health stability. He's been my best friend since 2000. And I think a lot of it was my mental health acting out. And I'm trying to work on that. I've started some new meds. But I put him in a situation that, we barely just bought our house. This ankle monitor's eating up, $300 a month. As I said, I'm on disability.
Excuse me. How do you know how much the ankle monitor is costing?
Oh, trust me, I've been on ankle monitors more times than you probably put people on ankle monitors, ma'am.
So you haven't talked with him about how much he's paying on the ankle monitor?
No, ma'am. But I've been on ankle monitors probably more times than you've issued it in your courts.
Are you paying for that out of your disability, his ankle monitor?
No, I'm not paying for that out of my disability. But regardless, I mean, disability isn't enough to pay for something like that. But regardless of what it is, I mean, what is the point of an ankle monitor? I don't see whose butt it's saving. Yours, mine, his. What is the ankle monitor doing for him anyway?
Well, before you started talking today, I would have said it's for your benefit, but now it sounds like it's for his as much as for yours. If you're coming on here telling me that you set him up, it was you that dropped the phone and damaged it, and that it was your mental health that caused him to be in this case, that makes it sound like maybe he needs protection from false allegations. If you're wanting to take that route and say these are all false and your responsibility, I'd say the ankle monitor is to protect you both, so you can't later say he came around you if he didn't.
Okay, he needs to be around me. That's my stability, my mental stability. That's how I get to my appointments. That's how you know what I'm saying? I don't function well without him. And I haven't functioned well without him since 2001.
All right. So you're basically here to ask me to lift the no contact between the two of you. Is that right?
Yes. And whatever else.
And to remove his ankle monitor to keep him in line with his relationship with you. You want the ankle monitor off of him too, right?
Well, I mean, that would make sense. I mean, he's paying for something for what? I just for the benefit of what? There's that an ankle monitor doesn't protect anything. The things that I did on an ankle monitor, you could only imagine. So,
all right. Thank you, ma'am. Thank you, Miss Swank. Does any attorney want to be heard on this
Yes,
request?
Judge.
Mr. Patterson, why don't you go first?
Okay. Judge, this is a case where I have spoke to my client. It is a case where we are asking to have a jury trial date set, but also based upon statements of Ms. Brown Judd, as well as my client would ask the court to remove the ankle monitor, the GPS. It is costing a lot of money, and asking to allow the contact and lift the no contact order. Thank you.
Okay, if your coworkers are asking you to explain things all the time, this is what you should do.
It's really hard for people to share what they know how to do with others. It's very manual and time consuming. Hi, I'm Jennifer. I'm the CEO and co-founder of Scribe. We're on a mission to make it easy to up-level everyone around you instantly and automatically. That's why we created Scribe, to make it easy and automatic to capture and share what you know how to do with others. Scribe will watch you do work and automatically create step-by-step guides that you can share with clients or customers to explain how to do something. What used to take me 17 hours to do, copy pasting screenshots, putting together an SOP, I can now do it in 15 minutes. We're here to make it easy for everybody to do their best work right from the start.
Mr. Regier?
One moment, Your Honor. As a preliminary matter, the state would have it noted on the record that the issue of lifting the no contact or the GPS monitor does not appear to be properly before the court. The state is not aware of any formal written motions having been filed with the court, so I am at somewhat of a disadvantage in this case. If the court is prepared to determine that that issue is properly before the court, the state would object to any modifications in prior bond conditions at this time. This is a case that appears to have multiple counts with domestic violence designations attached to the same. Notwithstanding any statements made on the record, this is a defendant with a history of prior convictions that the state considers relevant. If the court wishes me, I can go into those briefly. But again, the state's position, at least from the offset, is that this issue is not properly before the court, and if the court is prepared to take it up, the state would adamantly object to it.
You object to taking up the issue at this time?
That would be the state's first objection, Your Honor.
Well, I think we're a little late for that because we've already started taking it up. I understand where you're coming from, though, that you're surely perhaps blindsided, maybe not. Maybe the alleged victim has been to your office and made these statements before. Maybe she hasn't.
Your Honor, may I please speak?
One last time before I make a ruling. Go ahead.
I did write a letter to their office, to Miss Sarah Green. I did come in and speak with her again after the incident happened. I do have documentation that like a lot of my appointments he is present on. So, you know, I've tried to give them as much information as I can. I've tried to provide them with whatever. I have emails between me and Miss Green. You know, I don't know what else to further say on this issue. He
objects. Not to say anything further, okay? I understand I hear what you're saying. I don't think you need to keep trying to put it into words.
Yes,
I will tell you that with domestic violence victims, any of us that have worked with them with very much period of time, we know that even if you don't have an unhealthy mental health background coming into them, they can be very troublesome. They can play havoc with your judgment. And that's why the courts and counsel have the responsibility for setting up measures to try to protect you from what you may not know is involved with what you're asking. And so we put those protections in place for primarily the alleged victims, because we don't go looking for you and your husband to pick on or pull, separate. We get involved because whatever's happened between you has caused law enforcement to become involved. And I'm sure if you go back to the county attorney's victim witness provider, she can explain to you in more detail and better than I can in a short period of time why it's important to protect victims, alleged victims who may not even realize they need protection. That can happen with children, that can happen with domestic violence victims, because they just don't understand everything that's involved. We don't understand everything involved, but if we've been through this enough times with others, we kind of start getting some familiar patterns to deal with. So, first of all, Mr. Regier is right. There isn't a formal motion to modify the bond conditions. Second of all, even if there were, I am not sure that I have from you any kind of safety plan prepared from a safe house or a therapist to show that what you're proposing would be a protective measure. And then additionally, with what you've told me today, I would think that the defendant might be afraid of you making false reports on him, that if he comes around you, what's to say he's not going to get the police called on him again and be charged with more and more serious charges even. I don't know which one of you's done something wrong. If either of you, that's for the jury to decide, that Mr. Patterson has asked for. They will hear both of your evidence, both of you maybe. They'll hear from Mr. Regier's evidence, including you or not with you. Mr. Patterson will have the opportunity to present his client if he wants, or any other evidence. But that's going to be for the jury to decide. I will grant a jury trial. Jen, when's our next jury trial? I've forgotten.
Pre-trial is February 23rd, Your Honor, with jury trial beginning February 25th.
February 23rd is pre-trial. February 25th is jury trial. We don't have any in October this year.
Waste of money.
Does your dog's breath smell like shit? This product is for you.
You do have one coming up with pretrial. It'd be in September 29th. I was just concerned that that would not be enough time to prepare.
That would be the state's concerns as well, Your Honor.
Understood. Okay. All right. So the next available, I will set this, Mr. Patterson, at the defendant's request for jury trial. I trust you'll be filing appropriate documentation.
Yes.
February 23rd at 9 a.m. will be the pre-trial by Zoom. Actual jury trial will be February 25th, live in person at the courthouse, Mr. Swank. And those are both in the year 2026. Ms. Swank will get a subpoena if necessary to be present for that from the state. Okay, so that's the first order of request today, is to set this over for jury trial. The next is, I am not going to allow contact without further mental health experts. And that's not only just to protect you physically, Ms. Swank, but to protect Mr. Swank from any false allegations. I don't know what's right and wrong. I have heard bits and pieces, but the jury will hear it all in February and they will decide.
So what would you like from who?
Well, go back to the county attorney and talk to them more.
He's an idiot.
Or you go hire a witness, you go hire an attorney of your own if you don't think you're getting what you need there. But you see, you have victims' rights, and that's why I'm letting you speak today, even though there's not a motion on file, because I believe that you do have the right to be heard even without a motion on file. And that's why we're taking this up briefly today. But if we're going to take it up any further, you're going to need to get an attorney or go back to the county attorney and let them represent you on this motion. So that's what I'm going to direct you to do. And we can take that up February 23rd or sooner if the parties or an attorney want to ask for an earlier date on that sole issue of bond modification.
So there's no specific thing that you want for the courts from my doctor?
I'm not going to tell you how to present your case. I want you to get with an attorney and let them present their own case.
All right.
Okay. All right. If there's nothing further, counsel, Mr.
I'll from the
Revere,
state, Your Honor.
Mr. Patterson.
Nothing further today, Judge.
All right. Thank you all for your time. We'll be in recess with the Swank, and anyone here to just on Swank is excused.
Well, that's it, ladies and gentlemen. That is our Judge Webster docket. Tomorrow is Judge Washington, Judge Elaine C. Washington. So, you all have a wonderful evening. Ta-ta, chow-chow. I will see you guys again soon. And if you're not a subscriber to this channel and you like this content, please consider subscribing to this channel and helping this channel grow. That's it for me, ladies and gentlemen. I will see you guys tomorrow.
Come down to it all with your tools in hand, making magic flow. Every broken part, you help me grow. You solid ground, always drawing near. Never give up on this heart of mine. Put it back together every single time. To all you do, from the highest peak, I can see it through. With your care and touch, everything's okay.